Question number 18 is regarding judicial review of administrative action and the special jurisdiction of Supreme Court under Article 136 and social action litigation or public interest litigation and the very power of the Supreme Court under Article 32 and the very scope of Article 226 as regarding the powers of High Court and the very remedy through writs and the general grounds upon which relief under Article 226 can be refused by the High Court, and those portions we will discuss now exactly regarding judicial review. It has two distinct groups such as public law reviews, which is exercised through writs under Article 32 and 226 and Article 136 and 227, and regarding private law review, which is exercised through rules for damages, injunctions and declaratory actions. So, regarding that, this aspect of public law review was rightly expressed by the Supreme Court in the leading case S.L. Kapoor versus Jagmohan in 1980, as the very case two of the non-official members of the New Delhi Municipal Committee had filed an appeal before the Supreme Court under Article 136, in which validity of government action of superintending the corporation without complying with the principle of natural justice had been challenged. So, during the pendency of the appeal, the term for which the members had been appointed expired, and thus they apparently lost standing to continue the appeal. It was also argued that the appeal had become infructuous and the court had no power to continue with appeal. However, the Supreme Court held that since it is a matter of public importance, the court can still decide the issue even in the face of loss of standing of the petitioners. So, in regarding that, the Supreme Court, in other words, the threat of the fundamental rights may arise, and as it was raised in the following sources, as Government and Parliament of India, Government and Legislature of State and Local Governments, also by Government departmental undertakings, also by agencies incorporated by statute, also by agencies registered under statutes such as the Companies Act, Society Registration Act, etc. So also the court and private individuals and bodies from which the very threat to fundamental rights may arise. So, regarding High Courts have wider power to issue writs against any person or authority for the enforcement of fundamental rights and any other legal rights. As regards to the person and authority against whom such writs can be issued, the law seems to be in a thicket of inconsistencies. It is gratifying to note that the area for the operation of these writs has been extended, and rightly so, to cover various administrative agencies exercising multifarious functions. So, there is no dispute at all that all constitutional and administrative authorities are amenable to jurisdiction of courts. Therefore, a writ can be issued against public acts of the President of India, Governors, Union and State governments, ministers, government officers and departments and other bodies given in the Constitution, such as Union Public Service Commission, State Public Service Commission, Election Tribunal, Financial Commission, Water Dispute Authority, Advocate General of India, etc. And regarding private law review refers to the power of the ordinary courts of the land exercised in accordance with the ordinary law of the land to control administrative action, and private law reviews is exercised through injunction, declaratory action and suit for damages. And as regarding the very jurisdiction of Supreme Court as provided under Article 136, which is the nature of a residuary reserve power of judicial review in the arc of public law, lays down that the Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal except the court or tribunal of armed forces. So Article 136 also refers to tribunals, a term which necessarily refers to statutory body having the power to affect the rights of the people and the duty to act judicially. So a tribunal for the purpose of Article 136 must have some trapping of law, of a law court, which includes that the proceedings before it must stand on an application in the nature of a plaint, that it possesses the power of a civil court in matters compelling attendance of witnesses, discovery and inspection, that it allows cross-examination and legal representation, that it decides on the basis of evidence and according to law, and also that its members are qualified to be judges. On the basis of these elements, the Supreme Court found that the conciliation officer acting under the UP Industrial Dispute Act is not a tribunal, as it does not enjoy the powers of a civil court, as it was decided in the leading case, Jaswant Sugar Mills versus Lakshmi Chand in 1963. So also in the leading case, Engineering Mazdoor Sabha versus Hind Cycle Limited in 1963, the very way of arbitrator appointed under the Industrial Dispute Act 1947 is not considered to be a tribunal, as is appointed by the parties and is not invested with inherent judicial power of the state. So, the very question of social action litigation, the Supreme Court of India for the last few years has adopted a proactive approach, particularly keeping in view the peculiar socio-economic conditions prevailing in the country. This proactive approach is best reflected in the development of social action litigation, for which credit must go to Justice P.N. Bhagavati. According to him, social action litigation is a litigation which is intended not for the benefit of one individual but for the benefit of a class or group of persons, those who are either victims of exploitation or oppression, or who are denied their constitutional rights but cannot come to the court because of their ignorance, poverty and destitution. So, a person who professes to bring a litigation as public interest litigation should do so to achieve some public purpose and should not be motivated by some personal or private interest. If, on the other hand, a petition is brought with malevolent intention in the name of public interest to achieve some private purpose, it does not deserve to be entertained as public interest litigation as it was decided in the leading case, Prag Vyapar Mandal and others versus State of Uttar Pradesh in 1997 by the Allahabad High Court. In order to have a coherent view of this standing in social action litigation or public interest litigation, the following situational responses of the courts in India may be noted. One is standing, including notional injury and public duties, standing public duties, and the number 3 class standing, and number 4 it must be public concern standing also as it was expressed by Dr. Upendra Bakshi in his work as professor of law. So, under this category, not only the groups and organizations have been allowed standing, but individuals have also been granted access to the courts. And in the instant case, 2 professors of law from Delhi University were allowed to initiate proceedings for investigation into the functioning of a women's protective home in Agra, though neither these professors nor any of their friends or relatives were affected by the subhuman condition in the home. So also, as regarding the very questions relating to constitutional remedies, as regarding the very powers of Supreme Court under Article 32, so in public law, claim for compensation is a remedy available under Article 32 as it was expressed in 1995 by the Supreme Court in the leading case, Consumer Education and Research Center versus Union of India. So, in a welfare state, the primary duty of the government is to secure the welfare of the people. Providing adequate medical facilities for the people is an essential part of the obligation undertaken by the government. It discharges the obligation by running hospitals and health centers which provide medical care to the person seeking to avail those facilities. So, Article 21 imposes an obligation on the state to safeguard the right to life of every person, and as such, regarding the very powers as under Article 226 of the Constitution, the High Courts are entitled to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, statutory prohibition, and quo warranto. The directions, orders, or writs can be issued for 2 purposes: for the enforcement of fundamental rights conferred by Part 3 of the Constitution, and for any other purpose. The word any other purpose used here means the enforcement of any other legal rights. And as regarding the very question relating to the right to the remedy, and that also entitled those who are entitled to get remedy through writs. The very general rule is that a person whose right granted under Chapter 3 of the Constitution has been infringed can apply for a writ under Article 226. The person applying for the issue of the writ must have a locus standi. The courts have shown great flexibility and liberality of the approach in matter of locus standi. So, thus a person who seeks remedy under Article 226 must prove that he has a right enforceable by law under the Constitution. There has been violation or infringement of such a right. The above principles, for example, the existence of the right being the foundation of the exercise of jurisdiction is subject to certain exemptions, and such exemptions are firstly an application for writ of habeas corpus may in certain circumstances be made by the relations or friend of the person under detention, and secondly, in an application for quo warranto, it is not necessary that the applicant should have suffered personal injury or should seek redress of a personal grievance as regarding to the general grounds upon which the relief under Article 226 can be refused, and such grounds are that there is an alternative adequate remedies available, and the second that the conduct of the applicant is such that he does not deserve the discretionary remedy. For example, that he is guilty of laches or unreasonable delay, or that the applicant has misrepresented or suppressed material facts in his affidavit, so also that the very disputed facts have to be investigated in order to give relief to the petitioner, so also the writ would be futile or ineffective or of a mere academic interest. And next, we are doing during pendency of the proceedings under Article 226, the authority against whose order the petitioner brought the application offers to the petitioner, the court may dismiss the application without cost, with a note that no other order on the application is called for in view of the action of the authority subsequent to the filing of the application. And lastly, it is sound exercise of discretion to bear in mind the policy of the legislator to have disputes about special rights as in election cases decided as speedily as may be. The High Court should not therefore entertain petitions under Article 226 lightly in such a class of cases. So, in case when the students' union is not a statutory body and election of its office bearers is its internal matter, no writ petition under Article 226 of the Constitution is maintainable challenging the election of the Union as it was decided in the leading case Raghunath Dwivedi versus Vice Chancellor University of Allahabad by the Allahabad High Court in 1996. Also, no relief of specific performance of contract can be granted under Article 226 as it was decided in the leading case MS Lotus Construction versus Government of Andhra Pradesh in 1997 by the Andhra Pradesh High Court. So, these are the very relevant answers to those questions from question number 18 to question number 24 and those relating to judicial review and the special jurisdiction of Supreme Court under Article 136 and regarding social action, litigation or public interest litigation shall show the very power of the Supreme Court under Article 32 shall show under Article 226 of the jurisdiction of the High Courts and those persons who are entitled to get remedy through rates and under what conditions the High Court can refuse relief under Article 226. So we completed up to question number 24 and in our upcoming video we will discuss the rest questions, question number 25 to 35.